I'm Anthony Crowell, the Dean and President here at New York Law School, and we're honored to co-host this very special program featuring two presiding justices, one from New York, the other from South Africa, the presiding judge of Dianne Renwick of the Appellate Division, First Department in New York State, and the Judge President, Dunstan Mlambo. I want to thank our event partners, the Historical Society of the New York Courts and the New York State Supreme Court Appellate Division for the First Department for organizing the program. And of course, such gratitude goes to our own Professor Penny Andrews, who is going to moderate today's discussion. Professor Andrews, as many of you know, is the law school's John Marshall Harlan II Professor of Law. She's the director of our Racial Justice Project and herself is a globally recognized scholar and leader in our profession. Prior to joining the faculty here at New York Law School, she served as Dean at the University of Cape Town Faculty of Law and Dean and President at Albany Law School. And she's brought a number of extraordinary speakers to our campus, and today is no different. This is indeed a critical moment in time to host these two seasoned judicial leaders who can provide both local and global perspectives on constitutionalism and the rule of law. Both here and in many places around the world, of course, there is an ongoing struggle over the rule of law applying to everyone equally. And tonight's discussion takes place in that context as well. I also greatly appreciate the partnership Professor Andrews has developed with the Historical Society, which was founded by one of our state's greatest jurists, the late Chief Judge of the New York Court of Appeals, Judith Kaye. She was an inspirational leader to many, including myself and our entire law school community, which bestowed to her an honorary degree and featured her as the commencement speaker for our graduation 30 years ago. New York Law School certainly takes its role very seriously as a convening forum where substantive exchanges of ideas can take place and lead to a better and more representative judicial system. And we're going to continue our work with the courts to support their work, especially through graduating new generations of lawyers who want to make positive contributions and serve in public and judicial roles. So thank you all for attending this program. And now I will turn this over to Allison Morey, the Executive Director of the Historical Society, to introduce our speakers more.
Thank you, Dean Crowell. My name is Allison Morey, and I am the Executive Director of the Historical Society of the New York Courts. When Professor Penny Andrews reached out to me several months ago about a joint program between the Society and New York Law School that would explore the operation of the court systems in New York and South Africa and promote cross-cultural sharing and understanding, the decision was an immediate yes for the Society. We're a 501c3 nonprofit and the only organization dedicated to preserving and promoting New York's legal history. Our members help support initiatives such as this program that build an informed citizenry and promote collaboration between New York's bench and bar. Our initiatives also empower students to be better citizens and create change, capture living history and oral histories, and publish the unique legal history stories of the state, among other programs. Our trustee emeritus, Professor Andrews, will serve as moderator of this important conversation. Along with what Dean Crowell just introduced her as, she has held teaching positions at law schools nationally and internationally and served as the first Black dean at the University of Cape Town Faculty of Law and the first woman dean and president of Albany Law School. Professor Andrews will be joined by Judge President Dunstan Mlambo. The Honorable Dunstan Mlambo is Judge President of the Gauteng High Court in Johannesburg and Pretoria and heads the busiest high court system in South Africa. He previously served on the Labor Court, the Gauteng High Court, the Supreme Court of Appeal, where he was one of the first Black judges on that court, and he also served as Judge President of the Labor Court. As Judge President of the Gauteng High Court, Judge Mlambo has taken significant strides in transforming the judiciary from an all-white, all-male bench to one that represents the rich racial diversity of South Africa. Joining Judge President Mlambo to provide the New York perspective is Presiding Justice Dianne Renwick. The Honorable Dianne T. Renwick is Presiding Justice of the New York State Supreme Court Appellate Division, First Department, and she is the first woman of color to serve as Presiding Justice of any appellate division in the state, and only the second woman to lead the First Department since its creation in 1894. She previously served on the New York City Housing Court, New York City Civil Court, and New York County Supreme Court before becoming an Associate Justice of the First Department in 2008, which made her the first woman of color and fourth woman to ever join that court. Given the high caliber of our participants, this conversation will be most insightful. We're grateful to our program partners, New York Law School, and the Appellate Division First Department for this incredible event. Thank you, Professor Andrews.
Good evening, everybody. Thank you, Alison. Thank you, Dean Crowell, and ditto the word of welcome to everybody. What I'm going to do is ask the two judges some questions, and then we will leave time at the end, towards the end of the program, for questions from you, the audience. So let's start for both of you. Name one thing that you learned as an attorney before you became a judge that really served you well in the role of judge. And then name something that you wish you had learned, known before you became a judge. I'll start with you, Judge Renwick. Well, I would say what I learned as an attorney before becoming a judge was something I think I had learned as a child from my parents, and that was to treat people as you wish to be treated, to respect people. And then oddly enough, when I was in college, I was an RA, we learned mirroring or parroting, where you sort of repeat back to someone to let them know you're listening. People need to be heard. And so I think those things I developed further as an attorney and as one who practiced as an attorney, as a criminal defense attorney, first in the trial in the state court and then as a federal defender. It was, I think, imperative that I made my clients understand that I saw worth in them, regardless of what the offense was. Otherwise, there'd be no trust. There'd be no ability to work with clients. And so I think, and I feel very deeply, and it was extraordinary when I became a jurist as well, was to respect people who come before me, whether it's the litigants or the attorneys, understand that all parties, and I think it's part of due process, one of our fundamental underpinnings, is to allow people to be heard, give people the right to be heard, the opportunity to be heard, listen to them. And I think when that's the case, ultimately, I think justice flows from that. Something that you wish you had learned or known before? Okay. Something I wish I had learned before I became a judge is that, you know, when you're practicing, you're an advocate. You represent one side. And as much as you know when you become a judge that you must be impartial, impartiality is not something that just comes. You know, we still have our beliefs. And so I think just how important it is to be impartial, how much work it takes to be impartial, how it's something that we must consistently work at, because otherwise we're just not beating justice. And justice is elusive, right? It's not the same to everyone. So you sort of have to be, as I guess, in that listening, you have to be as impartial as you can be, but you also have to know that you're not going to please everyone, because justice to the plaintiff is not justice to the defendant. No one's ever happy. As they say, if you settle a case and both sides are unhappy, you've done a good job, but both parties are still unhappy. And so I guess what I have come to understand, and obviously I've been on the bench for a long time, it's a lot easier to be impartial, but it's just that it is constant. It's something we constantly have to work on. So, yes.
Thank you very much for having me here, Dean Crowell, and all of you here. me and Prof. Andrews come a long way. We are the products of the anti-apartheid public interest law fraternity, where we were schooled to practice law, not to make money, but for the benefit of society, especially those who are vulnerable. What I learned started early on, like Judge Renwick. My father taught me to be humble at all times and to respect everyone that I deal with. And what that taught me was to respect cultural diversity. In my years as a lawyer, public interest lawyer, I represented workers. I represented a lot of other diverse groups of people. I came across nasty people, rude people, you name it, those who'd done bad things in dismissing workers. But the teaching from my father stood me in good stead to respect them and to focus on the ball, so to speak, if I speak soccer language, not on the man. And that way, I was able to help my clients a lot better. We were in the Legal Resources Center, which was established by the late Chief Justice Arthur Charles Carlson, whom Professor Ellman wrote about. And it was a vehicle to provide legal access, legal representation to those who had no other options when faced with the might of the state. That was all dipped during apartheid. Something that I wish I'd learned was our constitution in South Africa is embedded on human rights and social justice. And I wish I had had an opportunity to study social sciences because it would have stood me in great stead as a judge. Let me leave it there. Thank you.
The next question is, all our contemporary arguments appear to be infused with politics, and not a particularly positive politics, but rather a toxic one. So we know that there is a disturbing amount of polarization and misinformation, and this has led to widespread cynicism among the population. So in your opinion, and this is not only in the United States, it's in South Africa and globally, in your opinion, what is the role and the place of the rule of law today?
Thank you. You know, well, we all know our society is changing, our world is changing. We have so much technology, we have social platforms that everybody and anybody can put information out on. And I think that means that we need to ensure that we are in constant conversation, constant discussion about what the rule of law is, what these concepts mean, and to begin at a young age with children. Some of you may know that I've started a civics program at the court called the Representation of Justice Initiative and Justice Forward, and it's because I think the only way we can begin to have a more intelligent dialogue among adults is if we teach children at a very young age what that means, how they fit in, even before they have an opportunity to vote, what the tripartite system of government is, which we have in the United States, help them to understand what they can do as young citizens. And I think we need to understand ourselves what our democracy is, and what the goals of that democracy are. And I'd like to share something if I could. There are two leaders in the law, and this is what they've said. There's retired United States Supreme Court Justice Anthony Kennedy wrote, "The rule of law holds special meaning for people of the United States because we look to the law to fulfill the promises of freedom, justice, and equality, which are embedded in the Constitution and intended to unite our states as citizens." Recently, in a speech, President Barack Obama explained, "Our democracy is not just a bunch of laws in some book somewhere. It's the values we live by and the way we treat each other, including those who don't look like us or pray like us or see the world exactly like we do. It's a sense of mutual respect." I think both of these explanations address the essential underpinnings of our democracy and our rule of law. And it's shaped by goals that embrace principles of freedom and fairness and equality. And I think those are built into the United States Constitution. While it didn't include Black men, didn't include Black people, didn't include women, we have sought to include that through amendments. And it's a living, breathing document. It is not one that is static. And it is one that by constantly having discussions, as I say, and constantly teaching its principles and its, what we are seeking, this tripartite system doesn't work with just the judiciary. There are two other branches of government, and we all have to respect and uphold the boundaries of each one of those individual systems in order for us to work and have a true democracy. And I think that, our constant view of that, keeping that in view, I think helps to sort of to get us there. I don't know if that.
Yes, yes.
I think I can sum up what my understanding of the rule of law is I always like to say the rule of law is the glue that keeps things together. Let me explain that. The larger majority of South Africans are still illiterate, and they are prey to misinformation. But we have recognized as lawyers and as judges that we need to ensure that South African society understands and know our constitution. It's one of the best constitutions around. It has a Bill of Rights that has a wide range of rights. But that constitution will be useless if the people it is meant to benefit don't know it and don't see it in action. And for it to remain true to what its objectives are, the rule of law is key. And as judges, we don't lose the opportunity when we get speaking engagements to go down to these gatherings and explain some of the processes that we engaged in. Let me give you an example. 2 years ago, I co-signed on an opinion in the Constitutional Court, which is the equivalent of your Supreme Court, which released Mr. Janus Wallus on parole. Mr. Janus Wallus is the man who was convicted of gunning down Mr. Chris Hani, the South African Communist Party leader in South Africa, a very popular man. It was important for South African society to understand why he, like everyone else, others who'd committed even more heinous crimes, were entitled to the parole system once they've complied with the dictates of what it they should do to be entitled to be released on parole. But that decision could easily have been misunderstood as the courts being rogue. So I come back to what I said. We have a democracy, some call it young, it's over 30 years old, but for it to continue to thrive, it is important for the Constitution to be known, to be applied, and to be understood by South African society to ensure that the rule of law continues to be the glue that keeps things in the right place. Thank you.
And just on that, just to pick up on that, it's just that, our citizens have to trust and believe in the integrity of the law and the integrity of our institutions. And if we don't uphold the rule of law, if we don't apply it in a fair and even-handed way as judges, or whether it's in the legislature, whatever the particular department is, if we don't uphold it with respect and integrity, they have no confidence in it. They have no confidence in the rule of law or in our institutions. So I agree. I think the idea of teaching so that people understand this and can grow to understand.
So important, particularly today. Judge Mlambo, I'm going to ask you a question about a trial, the Oscar Pistorius trial, that was widely watched all over the world, including here in the USA. Now, you made the notable decision on an application from the media in South Africa to broadcast the proceedings on television, radio, and the internet. It was a significant case that underscored the importance of freedom of speech. I wonder if you could speak a little bit to that decision and whether you think that trials, especially ones of great public interest, should be broadcast.
I watched a documentary flying over here of President Kennedy, and that the elections that involved him and President Nixon were the first to be televised. And it sort of resonated with what I wanted to talk about today, about what that ruling that I made did, the impact thereof. I spoke about ensuring that our society understands what we do as judges and as courts to remain faithful to the rule of law. At that time, the underlying theme in societal discussions, especially in Black society, was that we judges and the law were treating white people, rich people with kid gloves when it came to them being tried. And that was the result of South African society not being informed. So when the media applied for the right to broadcast the proceedings in that matter, it came to my court and I viewed it not recklessly, but as an opportunity to say, how can it be used to debunk this myth that we treat our citizens differently when they come to our courts? So when I say not recklessly, Oscar Pistorius was a very well-known Paralympian, rich young man. And he was alleged to have killed his girlfriend, River Steenkamp. There was a lot of interest shown in that matter when he applied for bail. So when the media came and made the application to say they want to be allowed to broadcast that trial, one had to look at our Constitution. What does it say? There are a number of competing rights that are involved in that matter. But the first prize for me was, it's no longer that difficult now, but then it was difficult for girl children to aspire to become judges because, especially black, because they were not aware of any prominent black female judges. So the decision was firmly rooted in my mind, even before I considered this application, that I was going to choose a black female judge to hear that matter. When the media came, Oscar Pistorius' primary objection to the broadcast of the matter was, it will erode his fair trial rights. His biggest point was witnesses would be able to watch and see what other witnesses are saying, those who come before them, and tailor make their evidence when they come. That was his main point. And the prosecution supported him, that they didn't want any cameras in the court. But that's one part of it, fair trial rights. Two, we have a constitution that guarantees what we call freedom of expression of the media. That's the next right. And that's the right that the media was relying on when they came to the court to say, look, we have a right. But additionally, our constitution openly propagates open justice. Now, when I considered the matter, I was alive to another provision in our constitution that says we have a Bill of Rights, we have a lot of rights, but they are not unlimited. They can be limited, right? In certain circumstances. I mean, Section 36 of the Constitution is very clear that where circumstances permit, the full enjoyment of a right can be curtailed. So what one had to do was to go on a balancing exercise, because we have many rights, but we don't have a system where some rights are more important than others. There's no hierarchy of rights. We treat all rights similarly. We just have to find a way as courts of balancing the interests that are at stake. I've mentioned open justice, but here's one other dynamic that comes into it. I also had to decide whether it was in the interest of justice overall to allow cameras in the courtroom. In addition to that, our Constitution says, and there's a section there, Section 173, that says, as courts, we have the prerogative to control and manage the proceedings and processes that happen in our courts. And that in doing that, we have to craft just an equitable relief in all the matters that come to us. So I've mentioned a number of aspects. I needed to balance all of them. How do I get out and come with just an equitable relief? The first place, it was not lost to me that what Mr. Pistorius was saying was not without merit. But one had to find a way at ensuring that you still have cameras in the courtroom, but you're still protecting its fair trial rights. When it comes to the media, say their right, freedom of expression was not unfettered. How do you find a way of ensuring that they still broadcast the trial, but they still respect privacy and dignity and the sanctity of the court proceedings? So with all that, what was primary in my mind was this was an opportunity to ensure that court proceedings involving the diverse characters in South African society are broadcast in people's living rooms. They actually see a judge who is black and female. sitting in judgment over a white Paralympian and manage the court processes. They had the opportunity of seeing advocates at play, plying their trade in the courts. And at the end of the day, the balancing act that I engaged was to say, there will be limited visual broadcast that would only involve opening arguments, closing arguments, judgments, as well as state witnesses. Because the defense objected to their witnesses being shown live, that was respected, to say they were not going to be shown live, but there would be audio coverage of the trial throughout, because television is powerful, but not every household has television, but they've got radios. And if this trial was covered through the audio mechanism throughout, you'd find people in taxi ranks, in spaza shops, in shebins, in the shacks, listening to the trial. It changed how South Africans viewed what judges do at the end of the day. And as I sit here, I remember talking to another dean at Pretoria University who said, the Oscar Pistorius trial led to a deluge in terms of people wanting to study law in all the universities, because they'd actually seen how it's done, what it means, and as well as the conclusion of that. Today, it's commonplace to televise court proceedings. So I was involved in a balancing exercise of ensuring I don't recognize one right over another, but I balance all of them to make sure that the broadcast still happens, but it still happens within a controlled environment. Thank you.
Thank you, Judge. And this is a question for Judge Renwick. Reigning in the enormous influence, including the power, indeed the power of social media networks like Facebook, it has become an item of urgent discussion in our society, and particularly the question of its role in our democracy and the rule of law. So you rendered a decision regarding Facebook in which you held that Facebook had neither a constitutional nor a statutory right to challenge allegedly defective warrants on its customers' behalf before the warrants were executed. And these warrants were issued in pursuit of fraudulent filing of Social Security disability claims. So I wonder if you could talk a little bit about that decision, and particularly the challenges that social media networks pose to the rule of law and democracy.
Thank you. So just to give a little bit more background, this was an investigation into fraudulent filings and with regard to 9/11 disabilities by police officers. So it was insurance fraud. And of course, sometimes there are, people put so many things on social media. You can find out more about a person looking through their accounts than you can going into their homes. So there are photographs of people, and I'm not saying these were the photographs, but hiking, swimming, doing flips, enjoying themselves, right? Those are the kinds of things you can see. And those are the kinds of things that were being sought, all kinds of photographs that would counter the allegations of injury. So Facebook, there were 381 warrants, and Facebook was challenging that and saying that there was no right to have the government get those 381 warrants. And it was a challenge because 381 warrants, 381 individuals, That's a lot of material. It was sort of like a wiretap where no one, the individuals don't know that they are being tapped. They don't know that the wiretap is there, but there is an extensive affidavit, and a court is required to review the affidavit and determine whether there's sufficient probable cause to exercise the warrant. Well, this was much the same. There was an extensive affidavit. The court had to review that affidavit and then make the determination as to whether the warrant could be lodged on Facebook to provide this information. And according to the law, there is no constitutional right to challenge an allegedly defective warrant before it's executed. Now, once it's executed, the right doesn't belong to Facebook. It belongs to the defendants. And the defendants were able to challenge, all 381 of them, were able to challenge the documents, whether they were applicable, not applicable, or whatever. But it did cause pause because I think there were only 60 or 61, something like that, charges that were ultimately brought. In other words, there are no interlocutory appeals in these cases, in criminal cases, so this is something that came up afterwards. There were only about 60 charges that were lodged, and 381, wow, that's 6 times that. It was very broad, it was very extensive, but it was over a decade ago, or just about. I imagine they have narrowed down the scope some way in looking at these kinds of cases. But it was, a real question of whether or not they were overbroad. We allowed it. It was affirmed by the Court of Appeals, and the appropriate challenges were made, as I said, at trial. It's a more difficult question to figure out how to rein in or how to, put checks and balances on media platforms that, under the First Amendment, have a right to express whatever they want to express and allow people to express whatever they want to express. In our society, if we speak a little bit more about what's reasonable speech, what kinds of things people should speak about and not, it's just beyond us. It's real difficult to put the genie back in the bottle. We've gone so beyond that. And I think, sort of like what I started off saying with our Constitution, we just need to continue to have dialogue and continue to have conversations about what's appropriate, what should be appropriate, what goes too far, why it's important. We see all of these things affecting kids. I just read something today about AI and a child who committed suicide because he was having a conversation with something that wasn't real, an AI that wasn't real. I mean, it just has gotten so far. But there are only certain kinds of limits that, as a court, one can place on these structures. In this instance, with regard to the warrants, we had to just limit it until the time where the defendants were able, as they were, to challenge the warrants individually. Does that answer your question?
Yes. Oh, yes. Thank you. Thank you. I wish we had more time to explore the cases, but so I'm going to ask one more question and then we will open it up for questions from you. So both of you, when COVID-19 shut down the world, everyone in institutions, large and small, public and private, had to pivot to ensure that their operations continued. For the legal system, especially the courts, this provided a huge challenge. I wonder if you could talk a little bit about how each of you, as leaders in your divisions, face the complex challenges that COVID generated. I'll start with you, Judge Locke.
Thank you very much. I hold the distinct recognition that when COVID hit, within 3 days of our president announcing the lockdown, my court, under my tutelage, had issued directives as to how we were going to continue doing our work, but safeguarding people's health. And that's the only court that remained open throughout. We had started implementing an electronic filing system called case lines, which enables you to have access to court proceedings wherever you are, as long as you have internet on your phone, on your laptop, or wherever. We started that in August of 2019, but in 2020 January, it became obligatory that when you litigate in my courts, you do it online, everything. All that we had to do when the lockdown was announced, to introduce virtual hearings. And whilst all the other courts were closed, I mean, the appellate courts only started operating around August. We were operating all along. The lawyers who were based in Gauteng, which is my province, thank me to this day that their bank balances remained okay because they continued to work whilst their colleagues in other provinces couldn't do anything. So through directives, we were able, and the directive is simple. We also created what you'd call public interest law courts for unrepresented litigants, that as head of court, I could issue permits enabling them to come to court where they found safe environments where they could participate in their hearings, aided by court officials. So no one was left behind. And that's what we did in Gauteng. I'm happy that we did that. Thank you.
If you had told lawyers in 2018 or 2019 in New York State, let alone the United States, that they were not going to be able to go into court and argue before a judge, look them in their eyes, see their reaction, sit with jurors in the same room, or they would have thought you were out of your mind. I mean, they just wouldn't have thought it was possible. Who would think that today lawyers are saying, I want a virtual hearing. I don't want to come into court. It boggles the mind, but it does go to see how adaptive we humans are, and we lawyers are, and how quickly we can pivot, and how new and innovative processes can help the law move forward and become even more efficient. We had gone to public hearings, I guess you would say, that we were able to view online what was going on in the Appellate Division. I think 2018 or 2019 is when we started that. But that's a very different thing than saying that all proceedings would be online. Everybody was in the court, and it could be viewed by those who weren't in the court. Our court was down for 2 weeks. That was unheard of. The Appellate Division was down for 2 weeks. And I thank the IT department far and wide across New York State because they worked miracles. And we came up with total virtual. Everything was online. All courts were online. We didn't miss a beat in terms of our appeals. Everyone got computers online. Everything worked. And we showed that we can work virtually. I think that something is a little lost in some instances. And so it is important that we have gotten back into the courtrooms, that we see jurors, that we can have trials. I think that's very important, but I think that we have also shown how efficient we can be in conferencing cases, in quick court conferences, and even in settlements and in certain kinds of courts where we can be more efficient to have things online. So it was a blessing and a curse for sure. There was such hardship, but from that, we found out that we can even be more efficient and effective.
Yes, necessity is truly the mother of invention. So we have about 13 minutes or so for questions. Anybody? Yes, I'll take the mic to you.
At the beginning of the conversation, Justice Renwick very importantly mentioned impartiality and judicial temperament, I suppose, as a whole. My question is, in the American context, is the election of judges at the state and federal level, the election of some judges, what does that do to impartiality and temperament? Is that the best way to, is that still a good way to select judges, or should the state and local systems go to the federal system of appointment? And I'd like to ask on the South African side, could you give us a thumbnail of how judges are selected in your country? Is there election of judges at any level?
Well, I've been appointed and I've been elected. And I would say that the appointed process and the elective process both have their issues. And I don't know that the federal system is any better. You know, for the federal system, you're tapped by senators who've seen your work. It's a lot of who you know and, you know, how well you're known. So I think that there are things built into both systems that could be improved. But I think ultimately, whether it's state or federal, you know, I think what you're really speaking about is that when one is elected, after the process of the several committees that they go through, then they're put on the ballots. Who knows them? The people who are voting for them perhaps don't know them. I don't know that the people know the federal judges until they're on the bench. So to that extent, I don't know that there's a real difference. And I think it comes back to, because there are forums where state judges do go and speak to the people in their communities. But I think it's about how active the people in the communities are about being involved in those kinds of activities. I mean, there are people who go into the ballot box, and if there's a proposal, it's the first time they're seeing it. There are people who go into the ballot and don't know who half of the parties are, you know? So I think it's a question about informing the public. Could we do a better job of informing the public? Of course, not just about state judges who are on the ballot, but also about the federal judges who are going before Congress and being, you know, who are being chosen in that way.
Well, the short answer about South Africa is we are all appointed, but we go through a public interview process where you are interviewed to test your fitness to be appointed as a judge. And the 23-member Judicial Services Commission is composed of politicians, judges, legal professionals, academics, and advocates, of course, legal professionals. And this whole group tests your fitness. It's a public process. Anyone who wants to come and watch can watch. It is also televised nationally. And after you are nominated to go for the interview, there's a process where there's a committee that shortlists the people who can go for the interview. If you go through the shortlist process, then the media publicizes a request or a notice by the Judicial Service Commission that if you have an objection against any of the people nominated for judicial office, file that objection, right? And there's a self-regulating system that looks at these objectives to make sure that unfounded objectives are thrown out at first base. But there are other objections where when you are sitting in that chair being interviewed, you are expected to answer to that objection, to say, this is the objection against you. Usually it's professional objections, but it's a controlled mechanism that ensures that people don't take a chance to simply hobble your candidature like that. So we're not elected, we're appointed through that process. I think that answers your question. Thank you.
Hi, thank you all for your extremely insightful and comparative perspectives on this topic. You both spoke extensively about the importance of visibility, both visibility with respect to like the rule of law at play and letting citizens understand the societies in which they live in, but also, and maybe more significantly, the visibility and the importance of the visibility of a diverse judiciary. I wanted to know, given the recent constitutional challenges regarding, I guess, things like affirmative action that have come up in the United States, I wanted to know what you believe, I guess, what the other options would be, whether or not drawing from the Constitution, what options there would be to ensure diverse judiciaries and visibly diverse judiciaries into the future.
One of the more striking differences between the United States Constitution and the South African Constitution seems, at least to me, to be the South African much more relaxed attitude towards standing. Could you elaborate a little bit upon what effect expanding the standing for the bring suits in the public interest, what effect that has on the judiciary, what effect that has on society? Does it, clog the courts, or does it create a windfall for justice?
You are correct that the South African Constitution contains provisions where a party who's completely not involved in an issue, in a matter, can apply to court to say they want to initiate these proceedings regarding that particular issue, because they will say either they represent a number of people who are affected by the litigation they are going to be issuing. And this is borne out by the fact that, you see, I told you we're from the LRC. South Africa has got a very vibrant civic space in terms of civic societies who litigate either to promote and protect rights that are in the Constitution. So it is in that regard that the courts view whoever wants to litigate in a space that you may look at it and say, but what is it of you? You're not involved, it's got nothing to do with you. But you can persuade the court that I represent these people and this is an issue, a class interest issue that requires resolution by the court, and the courts accept that because it's been viewed as one of the ways in which the rights in the Constitution are vindicated if you allow that approach to standing, right? So there's a lot of cases that I can cite to you about that, but I think that brief explanation probably tells you how we approach standing in South Africa. On affirmative action, I thought I'll talk about it because I sat in a matter where a police woman who was the best performing candidate in an interview was not appointed. She challenged that decision in the labor court and she won. to say she was unfairly discriminated. When it came to the labor appeal court, yeah, the white woman, yeah, she had black male opponents, but she was the best performing. She came, then the police services appealed to the labor appeal court. And at that time, I was the head of that court. And I interpreted the equality provision in our constitution, which has 3 legs. One is we're all equal. That's the first one, overriding. But the second part of that provision is, despite being equal, government is permitted to adopt national legislation or other instruments to promote people who were disadvantaged by past discrimination. That's the second part. And then the third part of that provision lists the number to say if you discriminate against a person because they're white or because they're black, that's unfair discrimination. We have very solid jurisprudence that, and that's what I followed, to say she's a white woman. She was not as privileged in the previous era of apartheid, but if she's appointed or promoted as she applied, it will not improve transformation or diversity in the position she was applying for. And I denied her that relief to say it does not promote the dictates of the Constitution to promote a white woman into an all-white structure. She appealed and went to the Supreme Court of Appeal. That reversed my ruling. But then the police services appealed to the Constitutional Court, our equivalent to your Supreme Court, which said, I got it right. Because the issue is the law permits that instruments may be created. The police had created an instrument to say when we advertise for positions, we are going to be promoting transformation, and we are going to be doing it in these following steps. She didn't challenge that instrument. She simply went to court and said, I've been discriminated because I'm white, and that's unfair. The Constitutional Court said, before you find unfair discrimination, first challenge the instrument. Does the instrument meet constitutional dictates? If it does, then your chances of proving unfair discrimination are virtually nothing. So I just thought, let me answer it that way. We've got very solid jurisprudence that establishes that we are all there to promote transformation of the South African society. And I can tell you now, had we not done that, had we not had a provision like that, I don't think I would be judged today. I think the South African judiciary would still be very much lily white, because you would not stop anyone. And people who'd been advantaged, I mean, I gave the example today earlier that in patent law matters, if you come to my court and the litigants see a black judge sitting there, they withdraw their matter, because black people don't get patent law instructions. They don't practice there. And the litigants say, how will this judge who knows nothing about patent law, how will they decide my matter? That's what we call briefing patterns. We still have certain pockets of work not going to black people, and that affects transformation. So I just thought, let me answer and give you those examples. Thank you.
Thank you. Well, I'll begin with the affirmative action. That was the first question. It's disappointing. I think that we are sort of ahead of South Africa in that we had affirmative action for a while, right? And now we've seen its erosion. And it seems to have affected, at least I think I saw the other day, statistics that in some schools, it was either the applications or the enrollment of African American, people of color has dropped. So it is having an impact. I think that at this point, the Supreme Court has spoken. We have to think of innovative ways, I hope, to get some case before the court that will have a different twist. But until then, I think we really have to look to the admissions offices of our universities to be creative. I know that some have looked to just a little opening in the decision. I can't think of it exactly what it is now, but it speaks about whether you have dedicated time to somebody help me out here to yeah, whether you've dedicated your time to diversity or something like this in your community, or whether you've something to sort of show, oh, this is a person of a diverse background, and so then you can look to people in that way. It's a shame because, of course, studies have shown that the more diverse a student body is, the more learning that takes place. The more exchange of intelligent ideas. It's not just one monogamous, idea. If we all thought the same, well, where would we be as a country? We are this country because of the diversity of ideas and experiences and strengths that have come from it. So the only thing I can say is that, we have to continue to be creative in the way we can seek out students, we can seek out, lawyers to work with us, and in every walk of life. But that's going to mean that the people who are making the decisions are open-minded to do so. So that was my answer there. With regard to standing, yes, we do have rules, strict rules on standing, because wow, floodgates would open and we would be overwhelmed. But we do have amicus briefs that do allow people who don't have, standing to bring the case to support various parties. And courts take those briefs very seriously. I just had a case where there were so many amicus briefs, I can't even tell you, but we allowed all of them and we read all of them. They all inform you in a different way, but of course, it's the main briefs that you're following, unless the others instruct you in some way. So that's, I guess, the way we get around that, the narrow standing.
Thank you. Well, Allison, yes.
What can I say? But wow, this has been a wonderful panel to share these insights into rule of law, democracy, judicial philosophy, and constitutionalism. Please join me in expressing our gratitude to Professor Andrews and Justice Renwick, as well as our program sponsors, the Historical Society of the New York Courts, New York Law School, and the Appellate Division First Department. We're happy to invite our in-person attendees to a reception just outside of this room, and we thank our virtual attendees for attending the program tonight. Thank you all.